and he's like all the way out there, and he's not going to get back in time, and it's going to smack the heck out of him. Even if he cures now, it's too late. He's going to have like 5 things happen to him now.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
You may remember there was a Steve Sands case. Steve Sands versus Bauer Media Group. You might not remember the title because it wasn't the title that was remarkable. It was Liebowitz. It was Richard Liebowitz who is representing plaintiff Steve Sands. And there had been some kind of discovery shenanigans. I believe Liebowitz had said that there was support for $2,500 or $5,000 in damages or something. And then the opposing side asked for basic discovery of those facts supporting the $2,500 or $5,000, whatever the damages were. And discovery of those facts would basically mean turn over the basis for your calculation. Emails, they said they had emails about licensing schemes and things like that. So if I own a photograph and I'm licensing the photograph out regularly, I should have all of the paperwork or electronic audit trail or whatever you want to call it representing the licenses I have given out, how much they were given out for, what the terms of the license were, and all that stuff. So you could then use that as the basis for demanding money when someone uses your material in a copyright infringing manner. This was the same case where Liebowitz had asked the judge, Judge Kaplan, to recuse himself because Liebowitz said that Kaplan called him a copyright troll. And Liebowitz filed a brief in protest or in support of his motion for recusal. And it was really well written. He really put his heart into it. I even was swayed a little bit by how he talked about the judge being prejudicial by using the term copyright troll, and how he's not the copyright troll. A plaintiff who was filing a million cases might be a copyright troll, but Liebowitz is just the representative, and it's thousands of plaintiffs that he represents, not one plaintiff in thousands of cases, et cetera, et cetera, et cetera. He really made some good arguments. Well, Judge Lewis Kaplan is here to shut all of that down. In the Steve Sands Bauer Media Group case, electronically filed 11/26/2019, Judge Kaplan writes in his memorandum and order, "This is a copyright infringement suit brought by Steve Sands, a photographer represented by attorney Richard Liebowitz. It is one of now well over 1,000 copyright infringement cases brought by Mr. Liebowitz in this district in the past 2 or so years. The matter before the court involves several issues ultimately stemming from the failure of plaintiff and his counsel to comply with discovery obligations. Defendant moves to dismiss the action on the ground that Mr. Liebowitz and or his client had committed discovery abuse, or alternatively to require a bond as security for costs and fees pursuant to local rules. On September 18th, 2019, the court concluded that the claim of discovery abuse was meritorious, but it declined to dismiss the action. Rather, it required Mr. Liebowitz to pay a reasonable attorney's fee to defendant for making and litigating the sanctions motion, and directed plaintiff to show cause on or before October 2nd, 2019, why the court should not condition plaintiff's ability to proceed with this action on the posting of a bond or other sufficient security in the amount of $50,000 for costs and attorney's fees in this action. So the case can proceed on the merits, but Leibowitz's client or Liebowitz have to put up $50,000 in order to proceed. The $50,000 sits in an escrow account in basically the coffers of the court, like a bank account somewhere, probably the court's IOLTA account, and it just sits there waiting for the outcome of the case, and then whoever wins the case or whoever then deserves that money gets it. If the plaintiff wins, the plaintiff gets their money back. If the plaintiff loses, then the $50,000 goes towards the attorney's fees or whatever cost the judge eventually assigns. Plaintiff opposed the entry of an order requiring the posting of security for costs and attorney's fees, but On October 22nd, 2019, the court issued a decision carefully considering but rejecting plaintiff's arguments. Its order stated that this action shall be dismissed with prejudice unless Sands, the plaintiff, on or before October 29th, 1 week later, posts a bond or other sufficient security in the amount of $50,000 for costs and attorney's fees in this action. Plaintiff never filed any bond or other security. Instead, plaintiff, on October 29th, moved to recuse the undersigned judge, arguing that the court's actions in this case have demonstrated personal bias against his counsel, Mr. Liebowitz, and that this alleged bias against him has resulted in actual bias against Plaintiff Sands. Discussion. It is more than passingly odd that plaintiff seeks to find support for his claim of personal bias against him and his counsel in the court's denial of his adversary's motion to dismiss this action for Mr. Leibowitz's discovery misconduct and its choice of the lesser sanction of imposing the costs of litigating the meritorious sanctions motion on Mr. Liebowitz rather than plaintiff himself. So the judge is pointing out that the judge has granted or granted something in favor of Liebowitz, or rather denied his opposing counsel's motion to dismiss. So Liebowitz prevailed on that one, and Liebowitz is still protesting. It is at least equally odd that the basis of the claim of bias is plaintiff's assertion that the court, on September 18th, entered an order, quote, in this action in which he condemned plaintiff's counsel, Richard Liebowitz, as a copyright troll, and accused him again of filing strike suits designed to extort settlements. In fact, the September 18th, 2019 ruling did not do either. Rather, it stated, quote, of course, photographers who create copyright images should be fairly compensated for their work. Those who infringe by using such images in violation of the rights of a copyright holder should be held to account. On the other hand, as the court noted in a prior case, there may well be justification for the implication that a significant portion of the 1,110 cases have been strike suits, designed to extort settlements from defendants on the basis that the defense cost would exceed what plaintiff would accept in a settlement. Indeed, another judge of this court has referred to Mr. Liebowitz as a copyright troll, one who is more focused on the business of litigation than on selling a product or service or licensing their copyrights to third parties to sell a product or service. A copyright troll plays a numbers game in which it targets hundreds or thousands of defendants seeking quick settlements priced just low enough that it is less expensive for the defendant to pay the troll, rather than defend the claim. Moreover, Liebowitz has been sanctioned, reprimanded, and advised to clean up his act by other judges of this court. As Judge Jesse Furman recently observed, there is a growing body of law in this district devoted to the question of whether and when to impose sanctions on Mr. Liebowitz. And that is what I am asked to do here by defendant's motion to dismiss the action as a sanction for alleged discovery misconduct, or alternatively, to strike portions of the evidence that plaintiff has submitted in support of a motion for summary judgment, or to require a bond as security for fees and costs. Thus, rather than condemn Mr. Liebowitz as a copyright troll, the court simply observed that another judge of this court has so characterized him. And rather than accusing Mr. Liebowitz of filing strike suits to extort settlements, the court observed that there might be justification for such claims, as indeed there might. In fact, as events have developed in this case, perhaps there is even more justification. Has Liebowitz ever heard of psychological projection? Someone alluded to someone being a copyright troll. I'm going to raise my hand and cry, me. I'm the copyright troll. Why did you call me a copyright troll? Like, wait a second. Nobody said you were a copyright troll. And then you suddenly like sprang to life and said, don't call me a copyright troll.
Methinks thou dost protest too much.
Yeah. In his zeal to deny that he files suits to extort settlements, Mr. Liebowitz, in this very case, in filing this very motion for recusal underlying this order, stated under penalty of perjury that plaintiff did not make a settlement demand in this action. Plaintiff stated similarly in his memorandum that he never made a settlement demand in this proceeding. He only ever sought judgment on the merits against Bauer Media. These statements are false. As both the court and defendant's counsel have pointed out, Mr. Leibowitz's associate made a $25,000 settlement demand at the initial conference in this case, a conference that Mr. Liebowitz did not attend. Even more glaring is an email defendant's counsel has produced, received by it from Mr. Liebowitz at the outset of the case, in which Mr. Liebowitz himself proposed settling for $25,000. Mr. Liebowitz has not disputed the authenticity or his authorship of the email, or argued that the associate lacked the authority to make the demand. He seeks to pass off his untrue statements by saying that he overlooked these $25,000 demands. He then implies that the notion that early resolution is generally promoted by federal courts is an excuse for making false statements under penalty of perjury. With respect, Mr. Leibowitz's assertion that he overlooked multiple settlement demands is unpersuasive. Nor is this the only occasion in which Mr. Liebowitz has made an untrue statement to a judge of this court. Count it down with me. In Bergina versus Imagina Consulting, it's actually Berger versus Imagina Consulting, Liebowitz sought to explain his failure to appear at an April 12, 2019 court conference by telling Judge Siebel in a letter written almost 3 weeks after his failure to appear, and in response to an order requiring documentary proof of the reason for his absence, that his grandfather had died on the day of the conference, and that Liebowitz was obliged to assist his family in certain religious customs in connection with the death. When pressed for documentary proof, Mr. Liebowitz voluntarily dismissed his client's action. Judge Siebel reiterated her demand for documentary proof. Instead of producing documentary proof, Mr. Liebowitz filed a declaration attesting, under penalty of perjury, that his prior explanation had been correct. Judge Siebel was not satisfied, and on July 26 directed Mr. Liebowitz to provide a death certificate for his late grandfather, whom he claimed had died on April 12th. Again, Mr. Liebowitz persisted in his refusal, arguing the death certificate was a personal matter. This resulted in Liebowitz being held in civil contempt. In due course, he was ordered to appear and show cause why he should not be incarcerated until he complied with the court's orders. In the end, facing the prospect of jail, Mr. Liebowitz produced the death certificate, which showed that his grandfather had died 3 days before the April 12, 2019 conference. He admitted also that the deceased grandfather had been interred on the day of his death. As Judge Siebel found, Mr. Leibowitz's repeated statements, some made or reiterated several times under penalty of perjury, that he missed the conference because his grandfather had died that day, all were false. And it seems perfectly obvious that Mr. Leibowitz's months of resistance to providing documentary proof to corroborate his claim that the grandfather had died, and perhaps the decision to voluntarily dismiss his client's lawsuit, were designed to avoid discovery of the fact that he had made false statements to Judge Siebel in the first place. As the Supreme Court held in Light Key versus United States, 1994, opinions formed by the judge on the basis of facts introduced or events occurring in the course of the current proceedings or of prior proceedings do not constitute a basis for a bias or partiality motion unless they display a deep-seated favoritism or antagonism that would make fair judgment impossible. So the standard is impossibility. That's a really high standard. Thus, judicial remarks during the course of a trial that are critical or disapproving of or even hostile to counsel, the parties, or their case ordinarily do not support a bias or partiality challenge. They may do so if they reveal an opinion that derives from an extrajudicial source, and they will do so if they reveal such a high degree of favoritism or antagonism as to make fair judgment impossible. Nothing in this record supports any claim of favoritism or antagonism, let alone favoritism or antagonism to a degree of making fair judgment impossible. For example, in this same opinion that plaintiff claims evinces this court's bias, the court observed, of course, photographers who create copyrighted images should be fairly compensated for their work. Those who infringe by using such images in violation of the rights of a copyright holder should be held to account. Moreover, at the conclusion of that opinion, the court declined to dismiss the case on the basis of discovery misconduct, although defendant had moved for such relief. So in other words, Liebowitz prevailed. For these and other reasons, the recusal motion is baseless. In view of the fact that plaintiff has not posted security for costs and attorney's fees as required by the October 22nd order, this action is dismissed. Mr. Liebowitz has sought an opportunity to make a further filing with respect to the amount of attorney's fees that should be awarded as a discovery sanction. The court sees no reason not to allow that, so the court will allow him to continue to argue over how much of a discovery sanction he should be suffering. For the foregoing reasons, the recusal motion is denied in all respects. The action is dismissed with prejudice for plaintiff's failure to post security as required by the October 22nd order. Plaintiff's motion for permission to file a further memorandum concerning the amount of attorney's fees to be awarded is granted to the extent that he may file such a memorandum, provided it is filed on or before December 6th and does not exceed 10 double-spaced pages. So ordered, November 26th, Louis A. Kaplan, United States District Judge, Southern District of New York. What do you think of that? Liebowitz is not going to get the judge to recuse himself. Liebowitz is still a copyright troll, and the judge says, no, you. Not me, you.
It's amazing. It's amazing that it's been 1.5 weeks and it's already starting to bite him in the ass, the Seabell Conference.
Yeah, the Seabell Conference just happened.
Yeah.
Literally what? 2 weeks? Yeah, it was 2 weeks ago. That was 2 weeks ago Wednesday.
What did that judge in the district court case, the district appeal case, say? That this will happen quickly in district court terms, but like this is like a week later and things are already happening? Like,
yeah, 2 weeks later, things are already happening against him. Yep. He's getting what he deserves. Now, I almost feel a little bad for him because he's obviously overstepped, and now the long arm of the law, like, it's like a rubber band. It's, you know, it's coming around, and he's like all the way out there, and he's not going to get back in time, and it's going to smack the heck out of him. It's even if he cures now, it's too late. He's going to have like 5 things happen to him now. He's going to have a disciplinary action from the Seabell case. He's got like 2 or 3 cases that are still wrapping up where there were sanctions of some kind. And I'm sure there are 1 or 2 more things hanging out there that have yet to catch up with him. So he's got some loose ends, and probably, and I have experience with this part, tying up loose ends. I don't mean disciplinary actions, but tying up loose ends. I've taken cases that took years to tie up. So I know what that feels like. And when you finally get those loose ends tied up, it feels like you've got a giant weight off your back. He's going to have that for a long time. So I feel bad for him because he's already going to be suffering. I know that he's going to be suffering consequences. Hopefully he can weather the consequences without hurting his clients, and maybe while still learning to do some good as an attorney. He doesn't seem to be a completely lost cause. So, but let me know. Maybe your opinion is that copyright trolls should burn at the stake. But, you know, let us know what you think in the comments below. And that is our show. Thank you for joining me. I am Leonard French, and this is Lawful Masses, your favorite legal news and story and education channel. Thank you very much to the contributors and supporters that make this channel possible. Thank you very much to our supporters on patreon.com/ljfrench and sponsus.com/law. Without your financial support, this channel would not be possible. Thank you very much to our $50 plus supporters in the month of November. Thank you to Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, SnorreW, Blackleaf, Benjamin Hitov, and Steven. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me and will be on the crawl in front of me. I will put some dog video up on the screen for you to enjoy while I am still speaking at you. I hope you had a great Thanksgiving, my friends in the US and abroad, and I look forward to a wonderful holiday season with you. I am Leonard French, your favorite copyright attorney. I will see you in the videos that drop. Love you all. Bye.
You wanna try something new? I know you don't like being put on the spot.
Sure, go ahead.
Why don't you just give us like a really good reaction, like before every story, to what you think, how you think you're gonna react to it beforehand. And then
I could do it afterward. I could definitely do one afterward.
Yeah. Okay, yeah. Try to get a good thumbnail after the thing.
Yeah, that's another thing. Another thing that I was thinking that we need to do is get thumbnails. Like I should like just basically at the beginning of this thing go, basically be like,
yeah, and I can leave that in my edit, and then you can just pick frames from it. So I can like just set up a template and put like the beginning part where you put the thumbnails in.